Hello, viewers. Welcome once again to Family Vibe TV. I am Kekom Ferdinand. I'm your convener. I'm once again your host. With me here on set again is Barrister Ifoma Christopher Ikewesi, a learned practitioner from JUK Chambers. She's a familiar face on this podcast, so she doesn't need much introduction anymore. Today we're going to treat a topic that says will. Or the will or a will, I don't know, but you know I'm talking about the will of a man. I think the man right prior to his death or before he is dead that they read, will, that kind of a thing, yeah. So that is what we're going to talk about today. And it is for you. I don't know what you are passing through right there, right now, wherever you are, but I know that this kind of topic can address it. Why not call your neighbors? Just come. Tell them to come. That we are at it again. Family Vibe TV, we are at it again. We are going to be discussing this topic under this following subheading. 1. What is a will? 2. Can a will be contested after a man's death? Then, what are the conditions for legally contesting the will of a deceased person? That man wait by, what is the legal conditions for contesting his will, assuming it does not go or in your favor? Then how do you contest it and at what point? Then what happens if the beneficiary of maybe dies before the testator? That's the deceased person, maybe he's not yet dead, then the person that's supposed to benefit from it dies before him. What happens? So these are the bullet points we are going to serve you with. You're not shooting to kill, you are shooting for you to learn, to be educated, to be equipped for your better life that we promised you on this service handle. And the former AKYC Christopher will be doing justice to that. So over to her, my learned colleague. Maybe you can still do a little bit mini introduction of yourself again, so that those that doesn't know you will know the vibe you are coming with.
Thank you for giving me the floor. I'm still my humble self, Christopher Ifoma Ikewes, a legal practitioner based in Oka, Anambra State, and Deputy Head of Chambers of Dr. J.U. Okoye. We are here on set again on the topic will, the last will and testament of a man. A lot of people feel that once you write a will, you sign a will, you're signing a death warrant. But honestly, it is not true, because so many people have actually written wills and lived longer after they wrote those wills. So you stay tuned as we address the topics. We'll take it one at a time. Thank you.
Issues for this country. We're also giving it based on what is trendy, what is happening. Recently, it happened again in this country. The family of a great man. Him, a financial person, deceased. Their case came up in court. Just watch this video with me.
We answer spiritual call just a year ago in Papa, and then one of his cousin, they no agree with waiting the will talk.
I try to ask myself, what it could make a 90 years old man just want to eye for a picking estate saying that he won't be part of the administrators then. He won't control. Why? Waiting is the see, waiting is still they live for much. Because you get the age you don't reach, you know they live again for materialism. You they live for waiting they talk about me if I don't go. Because you near your grave like say it's just a handshake from you. So that they try to sample the man. What do they think? Is it that the man they see something when the public need they see when make a like to correct her quickly before he go in grave?
The father now, they look and say, how would they like this now? Then when they leave these young ones to they manage all those big, huge business empire when this man get.
And when an outsiders they oversee them.
Yes. 26 years, now be the eldest daughter name Abi.
Yes, 26.
You understand?
The eldest daughter.
That one, matured she could be, but 26 is relatively young to handle that kind of business.
Now, having watched this video, you can now see that we are not just talking because we want to talk. We are talking because we are addressing the primary and basic issues of the society. What is happening? What is killing? What is troubling? Our aim is to heal the society by healing the family that make up the society. That's those families that make up the society. So I'll go back to the learned colleague here with me by asking the first question. What is a will?
Before going straight to the definition of a will, First of all, I want to explain some terminologies we'll be seeing in the course of this discussion. Okay, so who is a testator or testatrix?
Okay.
A testator or testatrix is a man, or rather the maker of the will.
Okay.
A man who divides or who distributes his assets through a will.
Okay.
If it's a man, he's a testator. If it's a woman, he's a testatrix. So either ways, they are the makers of the will that distribute their assets through the will.
Okay.
Then let's look at testate and intestate. What do we mean by testate and intestate? If we say testate, it means the deceased, or rather the testator, died leaving a will.
Okay.
If it's intestate, it means there is no will.
Okay.
So, in other words, testate refers to estate of the deceased covered by a will,
Okay.
while the other without a will. So let's look at estate. Estate in these aspects covers the assets of the deceased.
Okay.
You understand?
Okay.
The assets, we refer to it as the estate. Asset,
Okay.
both movable and immovable. Then legacy means the gifts in the will.
Okay.
So if we say the legacies in the will, it means the gifts given to anybody, the beneficiary.
Okay.
Then beneficiaries, we're referring to the people that benefit in the will, the people that the testator or the testatrix bequeaths or divides properties to in the will.
Okay.
Then the executors, these are people appointed by the testator or testatrix
Okay.
to manage or administer their estates after their deaths. They are appointed in the will
Okay.
as well. Then administrators, they are people that administer the estate of the deceased
Okay.
when it is intestate.
Okay.
Yes, they are the administrators. They can apply for letters of administration in order to administer whatever the deceased left behind.
It's okay.
Yeah, then the witnesses, we have witnesses. They are the people that witness the due execution of the will, and they equally sign or subscribe to the will
Okay.
after the testator must have signed. So let's look at what the will is. A will is a testamentary document
Okay.
made by a person with sound disposing mind, by which he disposes or distributes his assets and gives further instructions as to how his estate will be managed after his death. That is the definition of a will.
I want to know, can a will be contested after maybe the death of the testator?
Of course, yes, it can be contested.
Can you just inform the viewers more on that? What are the conditions for legally contesting the will of a deceased person?
Okay. First of all, there is what we call validity of a will.
Okay.
In making a will, one must ensure to confirm with these rules of validity of a will. First of all, it must be in writing. The testator must be of testamentary age to make the will.
Testamentary age?
Yes. It's defined by various laws of the states.
Okay.
But by Section 139 of the Administration and Succession of Estate of Deceased Persons Law of Anambra State,
Okay.
a person below 18 years cannot make a will. Such a will is invalid.
Okay.
You understand? So various laws of various states, they have their own definition as to age. Then aside from that, the will must be duly executed. When we talk of due execution of the will, it simply means that the testator must sign the will in the presence of two credible witnesses,
Okay.
which must be present at the same time. Mark the word, present at the same time. The two
Okay.
witnesses must be present at the same time.
Okay.
And the two witnesses will equally subscribe to the will in the presence of the testator.
Okay. Wait, don't be offended.
Okay.
When you say subscribe, you know these are legal terms. I know.
Yes, sign.
Okay, so
Sign as witnesses.
okay, before the person, before
Yes,
the testator.
before the testator.
Go ahead.
Okay. Then, other than that, the testator must have testamentary capacity. He must be of sound disposing mind as of the time he's giving such instructions to make the will,
Okay.
and at the time of executing the said will.
Can I ask another question here?
Okay.
Please, can you explain to the viewers what you mean by sound mind?
Sound
What are the
mind.
things that constitute sound mind?
Sound mind, you should be able to, you should be sane. You should be able to understand the gifts you're making.
Okay.
Understand, recognize your beneficiaries, understand the extent of the gifts and the estates you are devising in a will.
Okay.
So you shouldn't be, you should be coordinated. You
The person
understand?
should not have any emotional bias, psychological bias, or even health bias at all.
Exactly. You must be of good health, sound mind, then no form of influence or bias. But when we mean testamentary capacity, it really refers to sound disposing mind pertaining to health.
Okay, but to health basically.
Health, basically. You understand? If you can be mentally ill or insane and you make a will, it will be invalid. Once you comply with these conditions, it is presumed that the will is validly or duly executed. But when you fail to comply with these conditions of validity of a will, whosoever that wants to contest the will can capitalize on these conditions now, especially the issue of due execution. Because a lot of problems we have pertaining to will is whether the will is duly executed, you understand, or not. And then the fact that, my father was sick and bedridden, he wasn't the one that made the will was fabricated by whosoever that feels that they have upper hand in the family, you understand.
Okay.
So all these things are conditions that whosoever that wants to contest the will capitalize on. Then sometimes after reading of a will, the beneficiary, after seeing whatever that is devised in a will, or probably the will was read, I wasn't, as a beneficiary or as a son to the deceased, I was not given any property, any gifts in the will, I will say, no, this is not the will of my father. It was manipulated. Maybe someone else made the will and lodged it at probate. I will contest the will. You understand?
Okay.
I can say it is not my father that made the will.
Okay.
I can contest it. So many things, so many factors can lead to somebody contesting or challenging a will.
I want to add it to my questions. For instance, I've seen people while reading their will call a video team. Does that make any sense? Does that add to the validity of the will?
It is one thing to make such video, reading out whatever that is in the will. The law says by section 9 of the Wills Act, you must prove due execution of the will.
Okay.
I don't blame some people. Sometimes when they want to sign the will, or when the testator wants to sign the will with the witnesses, they want to do video coverage.
Okay.
It's better.
Okay.
It's not enough that you made a video reading the will. You have to prove due execution of the will. Okay. That is the provision of the law.
Okay. How can me, as a person, contest a will that I see and know that is kind of fault, not okay?
Okay. Is either the will is duly executed or is not. If you are challenging the fact that it wasn't duly executed,
okay,
after the will is read, if the testator dies, the probate writes to the beneficiaries / family members,
okay,
notifying them the date and the venue for the reading of the will.
Okay.
After the will is read, the executors of the will now apply for probate, grant of probate, to enable them administer the estate of the deceased.
Okay.
At that point, you as the aggrieved person, probably because you feel that this is not what your father ought to give you, you can contest the will by lodging, or rather putting in an application for caveats. There's what we call caveats.
Okay.
If you want to challenge the will, you lodge a caveat. Me as an executor, I apply for grants of probate, you lodge a caveat.
Okay.
Notifying and giving your reasons for contesting the will.
Okay.
Yes. Then from there, the probate registry will take it up.
So can such caveat halt the proceeding of will administration?
Of course. You can't be contesting a will and the executors will go on to administer the property.
So he has to wait until that caveat is sorted out.
Of course, the caveat, I think it lasts for 3 months.
Okay.
The caveat period, you understand? So once the will is read, within 8 days of reading of the will, you have within 8 days to enter caveat.
Okay.
Yes. So first of all, they will have to look at whatever you are contesting, dispose with it before they grant probate. Without the probate, the executors cannot administer the estate of the deceased.
Wow. And that will take me to our last question on the list. What happens if a beneficiary dies before a testator?
Thank you. You know, sometimes after you make a will, nobody anticipates that you will lose your child or maybe any beneficiaries.
Okay.
You understand? But then, after making a will and devising gifts to the beneficiaries, other than death, there are other ways that gifts made in a will can fail. A beneficiary may even decide that he wants to disclaim. Okay. He wants to reject or refuse whatever gifts because of whatever reason best known to him.
Okay.
At that point, it's assumed that the gift made to that beneficiary has failed.
Okay.
Then we have what we call failure by reason of attestation. When I'm a beneficiary,
okay,
and I also signed as a witness to the will. You can't be a beneficiary and then you are attesting to the will as a witness.
Okay.
The gift will fail. Another way is by ademption. A gift made in a will can fail if such property is lost or disposed of by the testator before his death.
Okay.
Yes, in that case, we say it has failed. And then the issue of the death of the beneficiary is referred to as lapse. When there is a lapse, it is deemed, or rather it means that the beneficiary died before the testator.
Okay.
Since he's dead, who are you making the gift to? Automatically the gift fails. But in this aspect of death of beneficiary before the testator, let's say the beneficiary has a surviving issue. If he dies leaving a surviving issue,
okay,
the gift will not fail.
That's what I wanted to ask.
Yes, the gift will not fail.
So gift is transferable.
Yes. The issue, the child of the beneficiary inherits that.
Okay.
But in a situation whereby there is total failure of gifts in a will,
okay,
it falls back to what we call residuary clause in a will.
Okay.
Yes. In that case, it means that those gifts that are in the residuary clause in a will, they form part of the how do I put it? They form intestates of the deceased estates.
Okay. Can you explain it further, please?
Remember that we are talking of testates. You left a will, but then the gift you gave or you devised in the will failed.
Okay.
They create an intestate estate.
Of the beneficiary?
No, of the testator.
But there's a will.
There is a will. There was a gift made, but
On
they
someone.
failed.
They failed?
Yes.
Okay, the person doesn't have any beneficiary as to someone that can claim it.
You
It cannot be transferred now because the person doesn't have anyone.
Yes. If the
Okay.
beneficiary does not have a surviving issue,
Okay.
the gift fails automatically. Like I said
Total
earlier.
failure.
Yes.
Okay.
So it falls back to residuary clause in the will, and
Yes.
it forms intestate of the deceased estate.
Okay.
In that case,
not covered by will.
Yes,
Yeah,
not
okay.
covered by the will.
Okay.
Yeah, there was no device. They can't act outside what is the instruction given in the will.
Okay.
You understand?
Now I understand. Yeah.
So in that situation, the best that the beneficiaries of that estate will do, the family members or the executors will do, is to apply for letters of administration to enable them administer those failed estates that forms intestates.
Or where is there any guideline to such application?
Yeah, you apply to the probate registry.
Okay.
You understand? Then they look at the application, they grant it, they grant letters of administration. So with that letters of administration, you can use it to dispose of these properties now that forms intestate amongst the beneficiaries. The truth remains that when a person dies, you cannot tamper or deal with the estates of that person without either getting probate in the case where he left a will or getting letters of administration. Just like somebody that will come and say, I want to buy a land. The land was owned by a Mr. A's husband. Since Mr. A is dead, the wife wants to sell off the land to me. You can't. As my client, I won't advise you to buy that except they get letters of administration.
Okay.
Or rather, that land that the wife wants to sell off was willed to her in the will. So she's probably the beneficiary. So she can dispose of it once the probate is granted. You understand? So that is it.
Wow.
Having explained and said all these things, it is advisable to make a will when you are healthy and hearty. I mean, why hustle, suffer under rain, under sun to acquire things, only for those things to be dragged after you are dead, or maybe only for the kindred, I think it's omona, to be the ones determining who owns your property or your sweat or whatever you've suffered to make in life. So I think I must encourage all of us to leave a will. It is necessary. It will solve a lot of headache on the demise of the testator. It is painful enough that families are dealing with grief of losing their loved ones, but it will even be more hardship when they have to fight over properties aside grieving their loved ones. So I will encourage all of us to try to put your house in order, do the needful, because nobody knows when you will answer the last call. Thank you.
That is massive. That is massive. And from the look of things, I didn't anticipate this depth that we covered here. I believe you got something. I don't need to add to this. Her closing remark is equally mine, so it is all encompassing. Just go out there and do what you're supposed to do. Do not allow your family to be dragged because of what you failed to do. I know a man that this type of thing happened to his family after his death. You leave a lot of money, and when you die, your family cannot have access to that. Your wife is thrown out of your house, a house you struggle to build with her. Most of what you have, she doesn't even know where they are. Your kids, they don't know anything. Possibly the death happened when the kids are still small, and now they are suffering. Tell me, who did you do all those things for? learn and do the right thing. Like I said earlier, I'm still proudly yours, Okekobusum Ferdinand, and we are saying goodbye for today till we see you next time. Thank you.
Ooh.